high and been irrepressible, and today I announce the rebirth of the OSP.
Boom. Abusia, the office of the special prosecutor abekasa na nsema okanyina yitia. Unim say na say ase wakwakoda kakra. Oban from mache obekasa yache yentenenka. Na sisi ya the office of the special prosecutor abekasa nsema na okeka menya botre metie komu odi no ena madumo suko. Now unim say what the charges be ababonte a charge nkrofo. Now the issue is say only no control say more na jiri pass you see the office of the special prosecutor no sabi inform anima amfa so bi answer the any so ntebe yanka yan scribe yam people fro yan direct officer no kro fro to say Ghana ha or to say ma me operation him na ono anka sa babonte e dey abetu ja say you what is ansem na comfort can but no as OSP no we in adwuma de as statesman we in adwuma sade aban no en omamu na hye ne se onye onfa fenchen kokro kronkroye ene no kodi enfa in adwuma na catch us say adwuma no we no more favoritism, no more nepotism, no more negotiable you are you no are you know. Office of the special prosecutor nkoma akogodia ene me so bi ema adwuma de so no win ade ba ko say do ejire pass open no why slow kakra. It's been slow. The work people are not convinced because you don't even see the benefit of that office, and therefore if the AG is available, why don't you scrap that office? And that is what some of Ghanaians are saying. But then I say that particular office now occupied, he's doing his work as a Ghanaian, as a leader, as someone who has been assigned to accomplish, to execute a particular job. And the job is for him to do thorough investigation about the self-acclaimed criminals. And that's exactly what he's doing. But so quiet and why interested why he didn't no. But so him the oil. But then I did back once I did say the oil in a Ghana ye dinty and I money yes and money and no I just the office of the special prosecutor. Honorable and I say papa Kissi Agyebeng komo kodi en Ankwanoma man na inti nsemo kodi en na mitwa me ba ye hu de beto aso
high and been irrepressible, and today I announce the rebirth of the OSP. To those who hold the view that the OSP has achieved nothing and that it should be scrapped, your claims are testable. To those who say the OSP is ineffective, your claims are testable. You are respectfully invited to check the statistics of our performance and benchmark them against your preferred institution, taking into account mandate, year of establishment, resources, complexity of cases, and legal constraints. If you do this dispassionately, it would occur to you that the OSP has performed creditably. Our performance is neither shrouded in secrecy nor obscurity. We pride ourselves with openness. As at 31 December 2025, the OSP was conducting the prosecution of 33 persons and had 79 cases at full investigation stage and 161 other cases at the preliminary investigation level. The OSP had secured 7 convictions at the same time through court-sanctioned plea bargains. Performance ledger transcends convictions and cases under investigation. Our mandate is not only in respect of investigations and prosecutions, it includes the recovery of assets and taking steps to prevent corruption. And by December 2025, the OSP had secured financial recoveries including 8.5 million cedis and $2 million, in addition to substantial movable and immovable assets in ongoing proceedings. The OSP has saved the nation billions of dollars in its work in the assessment of the risk of corruption, especially in relation to our natural resources and the potential loss of sovereignty over same, and our seaports. The OSP also safeguarded Tema Oil Refinery from being pawned off, and it is now in operation after years of inactivity. This was the OSP's work. The OSP's intervention in the customs sector has led to a reimagination and institution of a more robust auction of item system and a huge reduction in the often abused customs advance ruling regime in aid of the recouping of more revenue. The OSP's shake-up of the government payroll system has saved the nation a little over 100 million cedis so far. The OSP has saved the nation more than 20-fold the total amount of money released to its census establishment, and it has thereby fully paid for and far above the resources invested in it. No person, whether in the public or private space, now engages in corruption lightly. This is because such acts have become costly as a result of the operations of the OSP. These are measurable outcomes. These are verifiable outcomes. Criticism is legitimate. Scrutiny is necessary. However, they must be based on facts and not on baseless dismissiveness. The performance of the OSP should not be measured by political applause, social media volume, the preferences of persons affected by its work, or the preferences of those who dislike the institution and its officers out of sheer ill will. It should be gauged by investigations undertaken, persons prosecuted, assets recovered, losses prevented, systems corrected, public funds saved, and steps taken to prevent corruption. So when next it is said that the OSP has not performed, the answer is straightforward. Check the statistics and benchmark them against your preferred alternative. That is to say, no matter how much you disapprove of the DICA, acknowledge its notable speed and swiftness. On 15 April 2026, an Accra High Court sought to exercise powers which are the sole preserve of the Supreme Court and struck down parts of the Office of the Special Prosecutor Act 2017, Act 959, as unconstitutional. The High Court decided that the OSP lacks independent prosecutorial mandate. It invalidated all prosecutions conducted by the OSP, and it nullified all convictions and assets secured by the office. It then directed that all OSP cases should be handed over to the Attorney General. The court so decided, although there was a matter pending before the Supreme Court, which was directly on point of whether the prosecutorial mandate of the OSP under Act 959 was unconstitutional. This development brought the investigative and prosecutorial work of the OSP nationwide to a standstill and uncertainty. Other courts, except one, adjourned all proceedings, awaiting the Supreme Court's decision. Therefore, prosecutions stalled, investigations were gravely hampered, and corrupt actors became emboldened in their opprobrious conduct. The cost to this nation is staggering. Do the math on what we have lost as a nation as a result of what happened on 15 April 2026. However, on 29 July 2026, the Supreme Court delivered its decision in the much-awaited case of Noah Ephraim Tete Adamte against the Attorney General, which was to decide the fate of the OSP. Upon the filing of the writ by the plaintiff on 8 December 2025, the OSP sought to join the matter, acting upon our gathered intelligence that the Attorney General had no intention of defending the suit, and that he would rather agree with the plaintiff that the impugned provisions of Act 959 should be struck down as unconstitutional. However, we admit that intelligence is not evidence, and so the Supreme Court dismissed our application for joinder on 27 January 2026 by holding that the state, represented by the Attorney General, was the only proper defendant, and that the OSP was not a necessary party. Well, we tried, and the records so reflect that we tried. History may be kind to us for trying to join the suit and not merely sitting back. Subsequent events confirmed our intelligence that on 8 April 2026, the Attorney General obtained an extension of time within which to file his statement of case, in which he supported the plaintiff's case, albeit on his own separate grounds, Consequently, just as we feared and we forecasted in our attempt to join the suit stood undefended until named civil society organizations applied to and were permitted by the Supreme Court to join the suit and file an amicus brief as amici curiae, that is, friends of the court. In this landmark decision, the Supreme Court, by a well-reasoned and emphatic 7-0 verdict, upheld the constitutionality of the prosecutorial function of the OSP and its legal foundation and setup under Act 959, LI 2373, and LI 2374. And the Supreme Court expressly overturned the decision of every other court to the contrary. We express our appreciation to all citizens and organizations who continue to defend the work of public anti-corruption agencies. We set out for a special mention the following civil society organizations that defended the cause in the Noah Ephraim Tete Adamte case at the Supreme Court. Ghana Center for Democratic Development, Monkwaso. Transparency International Ghana, Monkwaso. Ghana Anti-Corruption Coalition, Monkwaso. Democracy Hub, Monkwaso. Star Foundation Ghana, Monkwaso. NORSAC, Monkwaso. Pen Plus Bytes, Monkwaso. Africa Center for Energy Policy, Monkwaso. Odekro PMO Foundation, Monkwaso. A. Rocha Ghana, Moso Monkwaso. Parliamentary Network Africa, Monkwaso. Imani Center for Policy and Education, Monkwaso. One Ghana Movement, Monkwaso. Africa Education Watch, Monkwaso. The OSP considers such civic vigilance essential to safeguarding Ghana's anti-corruption architecture, institutional independence, and the rule of law. We also salute the legal team of the Amici Curiae. Every page of your legal brief was a delight and an eye-opener, and this is coming from a law lecturer. The Supreme Court decision should be celebrated. It has set matters clear as to the functions and operations of the OSP and the coexistent relationship between the Attorney General and the OSP. It has greatly strengthened the fight against corruption, and it is upon the decision of the Supreme Court that I declare a rebirth of the OSP. We will show no fear or favor. We will remain resolute in the lawful discharge of our mandate. We will rigorously investigate cases. We will vigorously prosecute cases where the evidence indicates wrongdoing. We will actively recover assets. We will take all necessary steps to prevent corruption. This is our mandate. Recognizing that the fight against corruption will persistently be heckled by the pushback of corrupt actors, we have championed and we will continue to champion that the powers of anti-corruption agencies should be enlarged and enhanced, especially in respect of two main indices. First, global anti-corruption best practices indicate that broad-based lifestyle audit, non-conviction-based asset recovery represents the fairest and optimal method of frontally addressing corruption and unexplained wealth. Therefore, we have championed and will continue to champion that institutions like the OSP and the Economic and Organized Crime Office, YOCO, should be invested with express and effective lifestyle audit, non-conviction-based asset recovery powers to assure that persons show legitimate sources of income sufficient to justify their ownership of property. Therefore, where a person's resources far outstrip his legitimate income, the unexplained portion should be liable to confiscation. This will also be a critical tool to detect fraud and undeclared income for tax purposes. Added to this, conviction after criminal proceedings should not be a condition precedent for asset recovery. Civil proceedings should suffice. Second, we have championed and will continue to champion the institution of a reverse onus clause of a presumption of corruption tied to lifestyle audit. Therefore, where a person is in possession of property disproportionate to his known legitimate sources of income, he should be deemed to have obtained it through corrupt means unless he proves the contrary. This proposed unexplained wealth mechanism is not a shortcut around justice or a license for arbitrary confiscation. On the contrary, once the appropriate legal threshold is established before a civil court, unreconcilable assets not traced to legitimate sources of income should be liable to confiscation. Even though our investigative and prosecutorial work was gravely hampered after 15 April, we have not been indolent. We have reviewed all cases under investigation and at trial. In some cases, we have uncovered more evidence of wrongdoing. In other cases, we have identified more suspects. We are going to refile some of the pending major cases based on our discoveries.
Jabusa, eno eye Kissi Agyebeng no. O say more Nigeria pasanka office no, yen close no down. Because you know any good results bia, and far results bia emma, but on Nigeria pass the results papa beba. Ghana for money amotre. The good results ebeba. Eno I the office of the special prosecutor, that is Kissi Agyebeng nkoma okudi no busa. Yen scribing. And now say a man wo. Say so far so good under this government, you know. Initiative being then the under this government for this particular way, you know, a special prosecutor. Then for so be no one says so far I the South office no. Maybe na only be na me intimate mount on or conversation and then no first time so ban no subscribe to mommy. Political trends and as a brand TV so any.